Good afternoon, everyone. Allison Scoberg here, Consolidated Planning Group. We are happy to be here with you today. I always like to start with little housekeeping items, and somebody asked in the chat. We are in webinar mode today, which means that we can't see you or hear you, but we know you're there, and we're glad that you're here with us today. So don't worry, we can't see you. It's all okay. We invite everybody to put their questions in the chat box today. We had about four write-in questions that we have, and so if you emailed those questions to us, we already have them, and you don't need to ask those. We will address those today. So Consolidated Planning Group is a holistic special needs financial planning firm. We're nationally certified as Social Security advisors, members of the Special Needs Planning Academy. Our whole firm is nuanced in planning for special needs. And I always like to kind of make the difference between what someone like myself does and what like someone like attorney Heidi Angel does. I always say that they're the paper and we're the money, the legal documents, and we're going to be talking about those today, the wills, the trust, the guardianship. That's the legal side, the attorney side. We're the financial side. We're the money. How and when do we apply for benefits? How do we have money in the right buckets? How much money do we need to fund a special needs trust? How do I retire and stay retired and still have enough money to fund the special needs trust? Maybe you have other kids that you're planning college or other things for as well. So we help on all of those fronts. And really, when it comes down to the planning perspective, the financial planning perspective, having money in the right buckets, preserving eligibility for state and federally funded programs, helping people open up ABLE accounts, which we'll talk a little bit about those today. That's kind of what we do. So we are excited today to be partnering with Elijah's Retreat. And Cheryl, in just a moment, is going to tell us a little bit about Elijah's Retreat, and you can check out their website as well. I should mention that today's presentation is being recorded. Everybody that is registered for today's meeting will get an email with a link to the recording as well as a PDF of today's slides. So I'd just like to mention that so you know that you don't have to take notes on every single thing that you hear today, because you are going to get a copy of those slides. So having said that, welcome. We are glad that you are all here with us today. Thank you for that. And Cheryl, tell us a little bit more about Elijah's Retreat.
Thank you, Allison, and thank you for partnering with us and really being able to answer a lot of questions and just kind of guide these families through a lot of these really tough, concerning questions that provide a lot of anxiety for them. So thank you so very much for this opportunity. Elijah's Retreat is we're a 50-acre dude ranch for families with autism. So we are a nonprofit. We have over 400 families come out to Elijah's Retreat a year, and we are open from March 1st to mid-November. Each of the families has a little cabin that they get to stay in, but then we walk out autism with you, as far as we go and we introduce you to other families facing autism, but we also help them learn how to overcome fears of doing new things like feeding a goat or holding a chicken or holding baby bunnies or riding a horse and things of that nature. And so we have a lot of fun out here as a community wrapping around autism.
So, as far as families and interested in the retreat, where are you guys located? And then, do they apply on your website, or how does that work?
Yes, thank you, Allison. So we are located in East Texas. So we're about 2.5 hours north of Houston and about 2 hours east of Dallas. But we are, you can go on to our website. It's live with all of our reservations and different services and things that we do. Is on our website at elijahsretreat.com.
All right, awesome. Well, thank you for doing what you do. It sounds lovely. I have not been out there to tour yet, but I sure want to. So that's going to be on my agenda. So watch out. Here, I'm
We
coming.
love it, Allison. We love for you guys to come on out.
Yeah, for sure. All right. Well, thank you. Thank you for being here with us today. And I am pleased to be back with Heidi Angel. Heidi and I have done presentations in person and online in the past, and it's always nice and refreshing to be back with Heidi. Heidi has a broad understanding on planning for special needs. Like me, special needs is in her own family, so she eats, sleeps, and breathes this. And so we are excited to talk about all the buzzwords today when it comes to special needs planning on wills and trust and guardianships. So, having said that, I'm going to let you take that away, Heidi, because I know we have a lot to talk about. And if you're planning your day to day, we're going for an hour. So we aim to start on time and end on time. If we don't get through all the slides today, we'll schedule a part two. So just for planning purposes.
Perfect. Thank you, Allison. Appreciate it. And thanks, Cheryl. Appreciate learning more about Elijah's retreat. That's really neat. I'm excited about that. It fills a need for many families. So appreciate that. And yes, and I enjoy collaborating with Allison. I think she put it well when she says that I do the paper and she does the money, which explains why I'm on the bottom of everybody's to-do list, right? The paper is so fun. I love what I do. I'm an estate planning attorney primarily. I'm a partner at Jackson Walker in the Fort Worth office. I'm a board certified trust and estate attorney. Not all of my practice, but maybe a quarter of my practice is made up of special needs planning, which includes what we're kind of going between sometimes calling special needs trust and increasingly trying to call supplemental needs trust, because it's really a more accurate term to use than special needs trust. So you might hear both, but we're talking about the same thing. There are many different types of supplemental needs trust or special needs trust, but if we're saying supplemental or special, we're talking about the same thing. So I'm excited to talk to you today. As you can see here, I kind of like to lay out what my goals are. And so really what my goal is, it's not that I'm going to be able to address every question that you might have about your particular situation when it comes to planning or guardianship, but my goal is to try to provide you with a good framework of understanding so that you can be a good consumer of legal services, because for both guardianship and for estate planning, you are going to need to hire an attorney. And so my goal is to just try to make sure that people have enough information to feel a little bit more empowered than not having that information, and to be able to make good decisions moving forward, and not get drawn in maybe by some of the places that are using fear tactics to say, be really scared and freaked out and come get all this stuff done. No, learn. That's what we're here for. And then make good choices with how you choose to hire professionals. And then the other piece of that, my other goal is to just update you on developments in these laws, because those are ways that we can advocate for people with disabilities and following the lead of what's being promoted by self-advocates.
Heidi, I always just like to say that when it comes to your legal documents, this is not a DIY, do it yourself project. You do need an attorney, and I would argue that you need an attorney that is well versed and nuanced with special needs, because not all attorneys are created equally. Not all financial advisors have background in special needs. So your situation is specialized. There's plenty of areas in your life that DIY projects work out beautifully. But when it comes to your legal documents and these things, they're too important. And quite honestly, you can't do it yourself. Guardianship, you can't. There's some stuff that can't be done, but in the things that can probably shouldn't when it comes to special needs. So I always like to mention that, because I know, everything's expensive when it comes to planning for our loved one with a disability, and legal documents and things like that are expensive. But there are some things that we just can't afford to cut corners on, because what I've seen, and I know, Heidi, you've corrected other people's documents where they maybe worked with an attorney that didn't have any background in this or other things like that, you end up with problematic issues like a payback, a Medicaid payback, and a third party special needs trust that should not exist, or things like that. So people save money, maybe their neighbor next door did it for free, or your brother's an attorney in real estate or something, but then you end up having to pay somebody to fix the mistakes, and the mistakes do matter, and it could make a difference for your loved one.
Yeah, I do spend a good bit of time, correcting mistakes that have been made, or trying to educate on things that people were confused about some planning that was set up. And certainly in this day and age, a good question is, well, what could ChatGPT do for us? What if I put into ChatGPT, please prepare, a special needs trust? Well, that could go in a lot of different directions, but also our wills and our trust documents created, and we're Texas specific. I think most people here probably are, but it's possible some people aren't. But our wills and trusts are state specific. Our eligibility for SSI, Medicaid, federal programs, obviously that's federal, not state, but it goes through state programs. So the nuance of the language that needs to be in these documents is pretty significant. And what's available state to state is pretty significant. And I do like to collaborate with people like Allison because even in her language of saying I'm paper and she's money, I like that because I am dealing with planning all the time and it is heavily paper. I am actually not in the weeds on eligibility on a day-to-day basis. And the programs change names and they change eligibility criteria and there's new program. And so I do like to always just be really clear about what my lane is and what it's not. And there are parts of eligibility that I'm not an expert in. And so it is good to find the right professional. So that's what Allison and I are here to do, is try to do that and to make sure you have a good context for making these decisions and hiring professionals. So those are the goals today, and the purpose is just to help you be better advocates, both for yourself and for individuals with disabilities, including your family members. All right, and so we're gonna cover two areas. One is estate planning, including supplemental needs trusts, and one is guardianship. We're gonna start with guardianship. And I know people tend to have a lot of questions. Most of our questions that came in ahead of time were about guardianship. So I'm going to try to cover all of those, but then get to estate planning so we can get both of those covered. It might feel like a lot, and there might be some pieces of the guardianship that aren't covered. So just put those in the chat and we'll make sure to get to those. Usually when we do that, we're able to leave a couple minutes at the end where we can address anything that I've glossed over or haven't made clear. So starting with guardianship, and also Allison monitors the chat and she'll just jump in when we have a question that she wants to bring to my attention. All right, so starting with guardianship. So what is it? So guardianship is a court-created procedure. So it's where someone who's over the age of 18, where someone applies to the court saying that this individual needs to have the support of a guardianship to make personal or financial decisions for that person if they're determined to not be able to make those decisions themselves. And the reason for that is that when someone turns 18, they're an adult, they're presumed to have legal capacity to consent to medical treatment, to handle their own financial affairs, to execute a power of attorney. And that's actually on that next slide, Allison, if you're moving those. And to name an agent. So if, in my own estate planning, I've named an agent to act for me in the event of my incapacity, so that if something happened to me and I lost capacity, that agent can then make medical decisions for me, can handle my financial affairs so that I don't need to have a guardianship. So it's an alternative to guardianship. But a person with an intellectual disability sometimes lacks the capacity to be able to make medical and financial decisions. And so the idea of guardianship is that it is a protection for someone so that there is a person with capacity that can consent to medical treatment on their behalf. And there's two types of guardianship. So guardianship of the person is essentially being the guardian, the person who makes medical decisions for someone, who decides where they live and that sort of thing. Guardianship of the estate only comes into play if the adult has assets in their own name and they're determined to lack capacity to handle those. And so guardianship of the estate would be sought.
Heidi, I just want to talk about that for a second because Texas does that a little bit differently. Some other states, it's kind of guardianship of the person and guardianship of the estate go hand in hand and they just do it every time. But there is like a limit, and able account assets don't count. The assets in a special needs trust don't count. But and I think that limit was just raised. I don't remember what the limit is. Is it 20,000 now, or what is that number?
A limit on what can be in a
there's an asset limit that you don't need a guardianship of an estate in Texas. I think it's under 20,000. I'd have to
right.
double check that. I think it's 20,000 now. So that would be outside of an able account, outside of a special needs trust. And of course, if you have assets in a person's name over $2,000, you wouldn't be eligible for Medicaid. But I just wanted to mention, because we do have people that, listen from all across the United States, different states do it differently. And today what we're talking specifically is about Texas. So don't panic if you have guardianship of the person and you don't have guardianship of the estate. Most people don't have guardianship of the estate. Many people don't in Texas. So.
Correct. Yes. And that's a good point that, guardianship of the person is typically what people are reaching out to need to get because they need someone that can consent to medical treatment. Typically, you've had a doctor that said, we can't continue to let the parent make a decision for this adult who doesn't understand, what the medical procedures are that they're consenting to. And we need someone with legal capacity to be able to make those decisions and to consent to medical treatment. So that's typically it. The guardianship of the estate is typically not needed because if we've done the planning, we have the special needs trust set up. And so those assets never come into ownership by the person with the disability. So they're handled in the trust, exempt from the court supervision and exempt for SSI purposes and Medicaid purposes. And then maybe you have an ABLE account also, it's an exempt asset, so it's not one that anybody's concerned about. And then if you have SSI, then you have a rep payee who handles that particular bank account. And again, that one doesn't exceed $2,000 and you just kind of manage that one as the representative payee for the individual.
I just want to talk about that for a second because one thing that the Social Security Administration does not recognize, it doesn't matter that it's a legal document and it's legit, they do not recognize power of attorney. They do recognize guardianship. But I also wanted to mention that just because a person needs a representative payee does not mean that they have to be under guardianship. I want to make that clear because sometimes there's some confusion that in order to be a rep payee that person must be under guardianship, and that is not true. There might be people that have an intellectual disability, they can't handle money, or for any number of reasons, that you can be appointed a representative payee with the Social Security Administration. That usually requires a doctor's note or indicating why that person can't be their own rep payee. But it can be done and it's easily done. I just wanted to dispel that myth.
Yeah, thank you, because I think when we're talking about guardianship, we tend to be talking about, excuse me, individuals with intellectual disabilities and determining whether they need to be under guardianship or not. So all people with intellectual disabilities do not need to be under guardianship. And certainly there's plenty of people with disabilities receiving disability benefits who can be their own representative payee for Social Security purposes and don't need a guardianship or anything like that. And so I think that's a good point to make. When we're talking about guardianship, it is a very narrow and a very limited need. It is a very big concern to especially parents of children who have intellectual disabilities, because it's such kind of an unknown, and I think it's very stressful. And so it's one of the main reasons I like to talk about it, because I think it's not an easy topic to talk about because we're talking in such generalities. I can't tell you exactly whether your child needs guardianship or not. And so when somebody comes in to talk to me and says, I have a 20-year-old or about to turn 18-year-old, we're kind of going into this conversation of, and what we're going to talk about alternatives to guardianship. And so we'll get to sort of what that conversation looks like. But so just sort of setting the foundation here that this is what guardianship is. It is court created for a person who's over 18 years old, who lacks capacity in these specific spaces. And so they're tailored. Guardianship of the person can be tailored specifically to this person and limited to what the needs are. Guardian of the estate only comes into play if there's assets that need to be protected. There's pros and cons.
So in Texas, though, it's like least restrictive, most appropriate. And I like to encourage parents to say, because sometimes this feels scary. I mean, you've always had rights until your child turns 18. And it feels scary of knowing what I should do or shouldn't do. And our kids really haven't arrived at 18 and what they're going to be at 30 versus 18. But I just like to encourage people that the attorney that you sit down with, their job is to talk to you, to talk to your loved one, to find out about capacity and to lead you in that right direction that is least restrictive and most appropriate for your family, your situation. So I just like to tell people, you don't have to know what you need when you go to sit down with the attorney. You know that you need to have a conversation about guardianship or alternatives to guardianship to find out what path might be the best path forward for you. So I feel like it's pretty scary, the whole process is, and it doesn't have to be bad. But all attorneys, whether you work with Heidi or somebody else on the guardianship process, they're charged with having those conversations with you.
Yeah. Yeah, that's exactly. So, there's pros to it, there's cons to it. It's restrictive. It's a restrictive action. It should be taken in very limited circumstances. You have the court involved in your life, and You're taking away rights, civil rights from an individual in order to protect them. And as advocates for people with disabilities, that is not on the top of our list of things we want to do at all. So you want to be really, really cautious about this. So I often have people that come in and say, you know, my child with a disability is about to turn 18 and I need to come talk to you about estate planning and about guardianship and everything. And a lot of times my response is, let's get the estate planning done and let's just see on the guardianship. It's always available to go and apply to the court for guardianship. Unless there's some immediate medical need, usually you can hold off on it and just see. And not to take the thought process lightly, but most people who have an 18-year-old would like to continue having control over their legal medical decisions, right? I mean, most of us who have a child turning 18 don't feel like they have the maturity to, you know, be able to make all of their decisions completely independently. I'm not sure that I make all of my decisions independently, right? None of us are making decisions completely independently. We need the support of people no matter what. And so I think it's important to think that way and to support the person with the disability for as long as you can in not having a guardianship. Now, I have people that come in and have a child that it seems pretty clear that they do need that, and there's some medical reasons that they need to do that. And then we rush to get it. But absent those really narrow circumstances, a lot of times we can kick guardianship down the road. And for some of these cons, which it can be costly and that kind of thing. And so let me talk just a little bit about the guardianship application process. Again, just trying to inform, just so people kind of know what this process looks like.
I have a question on that lesser restricted options, like, you know, partial guardianship or power of attorney, supported decision-making agreement, which is in Texas, it's in some other states, not all of them. But if a person, like, so let's say a person goes with a lesser restrictive option, but that individual really can't handle finances. They really couldn't get them to doctor's appointments. Like I use the example, and this is an extreme example, but we've seen a lot of it in Texas over the last few weeks, where both parents die suddenly and the person really can't handle everything on their own. Is that then you rush and get a guardianship at that point, or what happens in those examples? So we understand that parents and family members help and they step in and they help with these things, but if they're no longer here, then how does that work? What happens?
So, I mean, my gut reaction would be no, we don't rush to guardianship, but I know there can be some very difficult situations, right? And sometimes it's this interplay between the family law court. So you might have an adult disabled child and two parents who are no longer married. And so they're trying to, you know, negotiate what possession and access looks like for an adult disabled child. And so this is sort of analogous to what you're saying. So then we have a situation, an adult disabled individual has just lost both of their parents, which is their entire support system. Does that now make them have less capacity? No, their capacity didn't change. Their legal capacity, their need for guardianship didn't change in that sense, but their support just got taken out from under them. So it's almost, it's tricky, right? Because their capacity didn't change, but their support did. And so ideally the support needs are what need to come and be filled in. Sometimes guardianship ends up taking that place, right? Because without the support, they do lack the capacity to do these things. Sometimes with the support, you know, and that doesn't really make sense, and it's kind of tricky, but.
No, I get it. But I think capacity, and one of the things that I will see, because I've seen the other side of this, is capacity is a slippery slope, and it's not a magic number. You know, a person has an intellectual disability, an IQ of 70 or below, 75 and below with multiple disabilities. We hear the number 69. Those are, you know, numbers that they throw around with an intellectual disability, but capacity is key, because the truth is if our kids have the ability to sign, most of our kids would sign something that we put in front of them. If you said this is good and you need to sign this, they would probably sign it. But we have seen issues where it came up where they said this person never had capacity to sign a POA. They never had capacity. They don't have capacity now, and they didn't have capacity then. And so I think that that's why it's so critically important to work with a professional such as yourself to talk through these things, because the capacity really, really does matter. And it's not a matter of just getting a signature. Just getting a signature on a page will work for the meantime, but when the rubber meets the road, when the crisis happens, when there's a big issue, that's when it comes up where maybe it was a mistake, if that were the case.
Right, and I certainly would never suggest, and I know you don't either, to, somebody signing something that they don't know. But if you'll skip forward to the alternatives to guardianship, and then I'll go back and talk about the application process, go one more. So alternatives to guardianship, we talked a little bit about guardianship of the estate. That's the money side, right? And that it's kind of rare when we need a guardianship of the estate. And if you have a supplemental needs trust in place, then you don't need a guardianship of the estate if that's holding all of the assets that are benefiting this individual. Establishing joint bank accounts is more or less in the context of usually like a married couple or something. You've got joint bank accounts so that the spouse with capacity can manage the bank account. Having a represented payee account, and then if somebody can have a financial power of attorney prior to losing capacity, then that can be an alternative to guardianship. Guardianship of the person, though, so medical power of attorney, if you were able to sign a medical power of attorney before losing capacity. But in most of our scenarios that we're looking at right now, we are typically family members trying to prepare for adults with intellectual disabilities. So the one that we're typically dealing with is in Texas, the supported decision-making agreement. And that exists in several different states. This came into Texas in about 2014. And in 2014, or 2015, that legislative session that gave us the amendments to the guardianship law provided, number one, that you an applicant for guardianship must consider alternatives to guardianship. If there isn't an alternative, then you need to use it. And when you're going into your application for guardianship, you have to show the court that you have looked at alternatives to guardianship. When we talk about ways that self-advocates and people advocating for people with disabilities have changed laws, this is a big one in Texas. This was definitely driven by self-advocates who were trying to limit the use of guardianship over them. And for good reason, they got a good law passed or amended this law in a very good way. And so the law, now you must look at alternatives to guardianship. And then the law also gave us one, the supported decision-making agreement. Sometimes we refer to the supported decision-making agreement as like a power of attorney light. Not a great definition, but it's kind of one way to think about it. So the supported decision-making agreement is specifically for people with an intellectual disability. So it is somebody that we think might not have the capacity to enter into a medical power of attorney. So to enter into a medical power of attorney, someone has to have the legal capacity to sign a contract, to enter into a legal agreement. And so if someone lacks the capacity to do that, and again, whose judgment? Is it the neurologist? Is it the doctor? Is it the lawyer? Some combination of those. Ultimately, it's the gatekeeper. Ultimately, it is the hospital that you're trying to use it at and saying, no, I don't believe that they have the capacity to enter into that power of attorney. So it's who you're needing to use it with is the ultimate gatekeeper on that. So a supported decision-making agreement, when I am working with an adult who has an intellectual disability, and I'm talking to them about a supported decision-making agreement, if I can have a conversation with them that goes along the lines of, when you go to the doctor, who do you like to have with you? Or do you like to have someone with you? Do you like to have mom there to help you understand what the doctor's saying? Because sometimes it can be really complicated. Does that help you? Do you want to have that? And typically in these scenarios, the individual will say, yeah, I do. I need my mom there to help me make that decision, or I need dad, or I need both of them. And so in those scenarios where I feel like the individual understood my question and can indicate verbally or non-verbally or however they communicate, they can tell me who they want to support them, I feel really comfortable having them sign the supported decision-making agreement. But that's the process that I go through with them. I would never put a piece of paper in front of them and say, sign this, because it'll make it easier for your parents. And so sometimes those are really tricky. Sometimes I'm not sure. Sometimes that day I wasn't able to connect with that person, and I just have to tell the parent, I don't feel comfortable asking your adult child to sign this today. So those are kind of tricky. But when I have somebody who can sign those, and we use them, and they're wonderful, and what they do is they allow the supporter, who typically a parent or family member, to be a part of the decision-making process with the individual with the disability, so that if you're in the doctor's office, the decisions can be made together. They're not making the decision for the individual. They are really there as a supporter. And so that's how those work. And that can bridge the gap between medical power of attorney and guardianship. So you might have more questions about that. I'm happy to talk more about those. But they
Do you want to
are,
go back in the slides or move forward?
let's go back and I'll talk about the application process just to make sure I've covered that. All right, so a couple of slides back, we have the guardianship application process. So this is what it looks like. So if I sit down with a family and we determine that there aren't alternatives to guardianship available, and we want to go ahead and file for guardianship of the person, let's say, we'll file an application. And then I did put in here, in certain circumstances, a suggestion of need can be filed. So if you knew of someone who needed to probably be under guardianship, you thought they were vulnerable to exploitation, you could file, anybody can file a suggestion of need, but the court can then do an investigation and see if that individual needs a guardianship. So there are other ways than just hiring a private attorney to file an application. And there are some legal aid options too, but I'm kind of just giving you my perspective as an attorney who files applications for guardianship. You submit a physician certificate, a CME, with the application, and that CME is a statutory form. And so the doctor fills that out and makes a determination about capacity. And then the court appoints an attorney ad litem, and the attorney ad litem's job is to represent what we call the proposed ward. So the disabled individual, the court appoints an attorney for them, and they'll go talk to the individual and ask if they have any opinions about the guardianship, if there's, anything that if they are contesting it or have any opposition to the guardianship. That's really important to know. And then all the parties attend a hearing, and then we have to present evidence, one about incapacity. So that goes to the physician certificate. The necessity for guardianship. Why do you need it? Well, we went to the doctor and doctor wouldn't let us consent to medical treatment. And then we have to prove that there's no alternatives available. So those are the prongs that we have to prove up in a hearing. It's also, this is why it gets sort of expensive, because you've got an attorney filing documents with the court and then, presenting evidence at a hearing and all of that. There has been some legislation proposed in Texas to shorten the process when it's a parent applying for guardianship for their child. That's been opposed generally by disability advocacy groups, because to sort of fast track guardianship really is not protective of the rights of individuals with disabilities without really going through an evidentiary hearing. Although it is frustrating for parents who have a disabled child where they really do need the guardianship, it's frustrating to have to spend so much money and time going through this process. But I do think it's important for due process reasons.
Somebody in the chat talked about that we should keep in mind that, a lot of siblings will become successor guardians of their disabled sibling. I just want to make sure that when you're talking about this, you talk about naming a successor guardian or how that works, because I think that is, that is something that all parents with a loved one with a disability thinks about, is what happens when I'm gone. And so let's talk about those successors.
Yeah, and the Texas Estates Code allows, of course, in the same way that you can sign a designation of guardian for my children in the event of my death or incapacity, you can sign a designation of successor guardian after you've been appointed as the guardian. So as a guardian, you can designate and sign a document that appoints the successor.
One thing that I think that stands out to me on this page, the slide that we have up, notify the court of any changes, including residence. And if you move to a different county, not country, county, you have to transfer the guardianship. So that is a real thing. And that includes people that have just moved here. Say you've just moved here from Florida and you had guardianship and you just moved to Texas. You're going to need to get those guardianships transferred. And I think sometimes people are not always clear on that.
Yeah, it's really an important point that you do have the guardianship is controlled by the county that you're in, and of course the state that you're in. And so if you're doing an interstate transfer, I've transferred them in from Florida and Illinois and Maryland recently, and they're all different, but we have to get a full record, certified copy of your full record from the other court, brought to our court, and apply for the transfer. Transferring county to county in Texas is much easier. That's not very difficult at all, but state to state is a little bit more of a process. But yeah, you have to go through the county. The other so the annual report is due each year. Importantly, if you just have a guardianship of the person, you don't need an attorney after that attorney's gotten you appointed. I mean, you can reach out to an attorney if reach back out if you have a question, but generally you don't need to be represented, which is a nice thing about guardianship of just the person. And there's some reasons why you try to avoid guardianship of the estate if at all possible, finding one of those alternatives. So guardianship of the person, you have to file an annual report each year. The form's online and it's not a difficult form. It just says, are they still living in the same place? Let us know any changes. If you have a guardianship of the estate, you have to be represented by an attorney, and that attorney has to prepare an annual accounting. And that can be expensive because, I mean, it's an accounting, you've got to account for the receipts and the disbursements and the taxes and all of the things. And so that's why it's pretty important to try to avoid guardianship of the estate if at all possible. And there's quite a few ways to do that. And so kind of scanning down through alternatives to guardianship next, which we mostly talked about. And then guardianship of the estate, there's also, you can do a 1301 management trust, which is an alternative to guardianship, where you have a bank serve as a trustee if there's a large amount of assets. All right, and so then we talked about supported decision-making agreements. That gives the code section there. I have a general letter that I give to clients that just explains, in lay terms, we're not making this up. This really is the law. You should accept this. The purpose of this is to avoid guardianship. And recites that code section there. All right, so the next one, alternative consent to authorize advocacy. It's an education power of attorney, and I give you a couple of resources there. TexasProjectFirst.org and the Dallas County Probate Court's websites have this. If you've got somebody that's in school, if they're doing an LVR program at UNT or one of the college programs, or even if they're still in their high school program until age 21, you might want to get an education power of attorney if you have people at the school saying that you've got to get guardianship to continue making educational decisions. A supported decision-making agreement you can use for this purpose as well.
As it relates, somebody asked if we had referrals for Austin. We have referrals for attorneys all across the state. And it really doesn't matter so much when it comes to special needs trust and legal documents. I know you guys do a lot of meetings by Zoom. Are there particular counties that you work in specifically in Texas for guardianship, or do you have counterparts in your firm that work all across the state?
I typically do Tarrant, Parker, kind of the contiguous counties around Tarrant. For the most part, we're a pretty large firm. I think we get a little bit too expensive in some of our Austin and Houston offices probably. But we were happy to make some referrals to local smaller firms. I think can do it in a more economic way.
Yes, we definitely have referrals, again, all across the state, including Austin, so we can help with that as well.
All right, let's see. Okay, we'll finish up. So one thing that's important just in that transition in ARG meeting, there was a change to the law that just said that the alternatives to guardianship, like supportive decision-making agreements, must be discussed with the students. And so a lot of times in these meetings, transition meetings, it seems like sometimes people were being told, okay, you need to go get a guardianship. And that just wasn't really good advice. So they must be, you must talk about alternatives for decision-making agreements and that kind of thing. So advocacy initiatives, I already kind of highlighted this, that in that 2015 session, the less restrictive alternatives to guardianship were implemented, which was really important. The Ward's Bill of Rights, which was just listing some rights that the individual will have, supported decision-making agreements, all of those were really important changes. And so I think it's good to keep those things in mind because there's changes that still need to be made. The law's not perfect. There's a lot of restrictions on people with disabilities that are unnecessary and unhelpful. And so it's important to just be knowledgeable and helpful in listening to people with disabilities and self-advocates and making those changes.
So the biggest rights that are taken away, I mean, I guess it's big to whomever you're speaking to on what is the biggest right taken away. But on a full guardianship, the right to drive, the right to vote, are there any other, I mean, obviously it's taking all of their rights away, but the right to drive, the right to vote. So
marry and to carry a weapon.
Okay.
Carry or purchase
so
weapon.
those are the big ones. And so, we have a lot of families that believe that their child will be able to drive in the future. Maybe we're not there yet at 18, but we're taking disability driving training and we're hopeful and things like that. So a full guardianship would take that right away. Are there any caveats to that or not really?
I mean, you could make a very limited guardianship of the person that just pertain to making medical decisions. That's certainly a way to go. There's also a lot of restorations happening. And so, back before 2015, I mean, I could just grab you and walk into the probate court and say, we needed a guardianship. I mean, it was just too easy. And so that was the purpose of these laws, to be more protective, which means that there were a lot of people put under guardianship that didn't need to be. And so today there are a lot of restorations of people's rights that are happening, either full or partial restorations. And so that's important to know too, that is possible and just something to consider.
Yeah, I think being encouraging on that front too, that just because, I mean, there are plenty of people that may actually need a full guardianship, but just because that's what they need now may not be what they need 10 years from now. So the restoration of rights is a thing that they can get back. And there's been obviously very public cases in the news of stuff like this that we've all heard of. But
Yeah,
so
if you Google guardianship and tech, you will find some stories that sound pretty horrific, as far as, taking people's rights and that kind of thing. And so I think it's important to take it seriously, to listen to self-advocates, and to be mindful of the rights of individuals. So how do we get here from here? Get there from here. What I mean to get there is, getting to where some of those alternatives to guardianship might work for us, right? My daughter with Down syndrome is 13. We have done person-centered planning since she was young. I found it to be very instructive to me to learn how to be a parent of a person with a disability, because I didn't grow up with an intellectual disability. So I don't really know what it feels like to be her. And, in a space where I'm wanting to make all those decisions for her and control things, I've had to learn what it means to support someone, empower her, give her dignity of risk, as increasingly as she gets older. And so learning a lot of that has been really helpful to me. So I suggest, reaching out to somebody that can help you work through person-centered planning. If you're at a stage like I am, where, you've got a child or a family member that, you're in a place where you can do that.
is there any specific organizations that you recommend for person-centered planning, in case somebody wants to check that out?
The best resources that I've personally found, so local to the DFW area, is the ARC. And so they have their A Look Ahead conference coming up on August 9th, and Allison and I have spoken at that before. They have such great resources, and if you can make it to that, it always, you'll have somebody talking about planning and jobs and transitioning to adulthood and advocacy and everything. There's a bunch of different tracks. There's self-advocate tracks. It's a great program that I highly recommend. That's August 9th, and it's the ARC A Look Ahead conference. From there, I've found several people. We worked with Debbie Wilkes. I'm not sure if she's still practicing in person-centered planning, but she was wonderful many years. I mean, it was about 6 or 7 years ago we worked with her. And then there's a wonderful guy that spoke at the last A Look Ahead conference that I went to, and I'm going to blank on his name right now. And I don't know if and I'm sorry, I should probably have some better resources there, but Navigate Life Texas. I don't know if that's only.
I feel like all like most cities have an ARC, okay? In and around the big cities, right? There's an ARC, and so they may be able to direct you. And then furthermore, in addition to the ARC, I think that like Autism Speaks, the Down Syndrome Association, some of their websites, I know that Autism Speaks has lots of toolkits on their website that are pretty awesome. So you may want to check some of those out. So there might be some referrals there as well.
Yeah. But I highly do recommend looking into somebody that can walk you through person-centered planning, because I think that leads us, at least I can speak just from a parent perspective, into having the right mindset of supporting our individual with a disability in the right way, so that they can be empowered to make a lot of decisions for themselves. So, and that's a lot of training that we need. Okay, so I'm going to switch over to special needs trust, supplemental needs trusts now, and I'm going to do it kind of quickly, but I think we can do that, and then I can answer questions. And I saw a question pop up about trust, so we'll try to handle that one. Okay, so estate planning means, what's going to happen with your assets, both during life and at death. And during life, that's, if you were to become incapacitated and having those power of attorney documents in place, and having someone that you've named be able to handle your assets. And then what happens with your assets in death. And so specifically for our purposes, what happens when our loved one with a disability inherits something from us, something small, something large, regardless. If they inherited something from us, if you have no planning whatsoever, and they're determined to be your heirs under Texas law, they would receive assets and then be knocked off of their benefits likely, right? They would have too many assets, be knocked off benefits until they spent it down. So a better way is to be able to, with your will, so my will says, everything to my husband, but if my husband isn't living, then everything equally to my children, provided anything that goes to this child should go to her special needs trust. And then in that way, I've protected those assets for her. So an overview here of just some of the estate planning terminology that we use. So wills, when you have a will, you name an executor. That just means the person who's going to take the will to the court and say, this was a validly executed will. I'm the person that the will named as executor. Court, give me the authority to now gather these assets and then distribute them according to the beneficiaries that are listed in the will. That's all the will does. A trust creates, so sometimes like the one I was talking about before, my will would say, executor, your job is to give this portion for my daughter over to her special needs trust. Okay, now there's a trustee of her trust, and that's just what's listed in the document. So the trust says so-and-so is going to serve as trustee. So executor talks to trustee, hands the assets that are due to that child over to be held in trust. And the trust has all the terminology in it that makes it work as a supplemental needs trust and creates an exempt asset for the purposes of eligibility for Medicaid and SSI. So that's how those sort of interact. The other pieces of your estate planning would be the powers of attorney that we've talked about, and an advance directive to physicians saying what your end of life wishes are. Insurance, and so it's sometimes life insurance might have a beneficiary designation to a special needs trust. It's a good way to fund them usually. Talk to your money people, your financial advisors on those. Retirement accounts, and coordinating your beneficiary designations of all of these accounts with the planning, with the wills and the trusts.
I want to hit on that, and this is my bandwagon.
Yep.
There is a big misconception out there that when you work with an attorney and you do your wills and your trust and you set everything up on who's who and all of that stuff, that it's just done. There is one more step. Life insurance contracts, investment accounts, bank accounts, things like that, they have beneficiaries, and the beneficiary trumps all that. So it is important to review your beneficiaries, and this includes your group benefits, your group life insurance through work, your 401k, 403b, your pension from 20 years ago. All of those things that we forget about. It is really, really important to look at those beneficiary designations. And furthermore, it is important to not name your loved one that has a disability specifically as a beneficiary on any of those accounts. The right way to do it is to name that supplemental needs trust, that third-party special needs trust for the benefit of said child, and that's going to maintain their eligibility for benefits, because remember, we don't want them to come into sums of money more than $2,000 to maintain their Medicaid eligibility and SSI. So I just want to hit on that, because I would say I'd probably say 100% of our webinars, someone on our webinar hasn't reviewed their beneficiaries in years. They never heard this before. They thought that the wills and the trust trump everything. So if you are taking notes, just make a note to check all of your beneficiaries and make sure that you have them set up the way that you thought they were and the way that they should be. And I always want to encourage and say, if they're not, don't panic. It's okay. It's a free change of beneficiary form. Now, if you don't have a special needs trust, that's not free. You'll have to pay to get one of those set up. But you can always change your beneficiaries with the carrier, with the company, your HR department. It's a free form that you can fill out and make those changes. It's not costly.
Yeah, when I meet with clients, my first step is list all of your assets. And what I'm trying to do is identify anything with a beneficiary designation so that I can educate them. Here's what the will is going to distribute or trust or whatever their plan is. And here is what's going to be, go by contract, the contract with your insurance company, the contract, your beneficiary designation on this account. And just like Allison said, that trumps whatever your will says. And so it's just really important to understand what controls different assets. And then when I'm finished with the planning, then I look back and say, okay, let's make sure everything is coordinated, updated your beneficiary designations, mention the special needs trust where needed and that sort of thing.
So somebody asked a question basically about testamentary special needs trust versus the standalone special needs trust and when a trust is created. So I want to make sure I know that we've got about 10 minutes left for today, that we do hit on the differences of those.
Yeah, that's a good question. And so if we had a room full of estate planning attorneys, we probably all do things differently and can't all agree on the same exact path. But there are attorneys who will put the special needs trust within your will. And if it's in the will, so if it just says, you know, everything goes to spouse and kids, but this kids goes to the special needs trust, and here are the terms of that trust, and it's all within the will, that trust is now called a testamentary trust. That trust can't really come into existence until the will is probated. So the person passes away, the will is taken to court, found to be valid. Now there's an order that says this will is valid and the executor is appointed, and now the trustee can be appointed under the trust. So then if somebody says we need the trust document, it is the will. I kind of got tired of having to answer the question, where is the trust document? Here's the will. Yes, it's the trust. Yes, it's a will. It's a testamentary trust, and trying to explain that. My practice now is to have the will is fairly simple. The third party special needs trust is just a freestanding. There's not a right or wrong way to do it. They're both perfectly right. My goal is always to try to make things as clear as possible for the Social Security Administration, because they will reject things outright just for a lot of reasons. So I have a freestanding special needs trust. It's an irrevocable trust. It has to be for the term, you know, when it's used, it's supposed to be irrevocable. It could be revocable when you start it. But again, I'm trying to make it as checking all the boxes that Social Security Administration wants to see. It's irrevocable. It's third party special needs trust. And so then it's a freestanding trust. You're not going to fund it during your lifetime is the idea. And there's some other planning ideas where you could have an account that's going to fund it and that kind of thing. But generally, you don't fund the special needs trust during your life. Then for that reason, you're not having to get a tax ID number for it. You're not having to file a tax return for it, anything like that. It's just sitting here. It's funded with $10. So it exists. You can list it as the beneficiary of any accounts that you want to, or as a portion of an account if you want, life insurance, beneficiary, any of that, it can be used because it exists and it has a name. And it also has a date that it was created. The day that you created the trust, when you signed all of your estate planning documents, that's the date it was created. Whereas a testamentary trust, you'd just say under will dated certain date. So it just makes it a little bit more complicated depending on the form you're trying to fill out. So I do it separately, but there's not an incorrect way to do it as far as testamentary or standalone, just a practice preference.
I think it is a practice preference, but I would say if there is a much lower level of assets involved, that sometimes the testamentary trust is just fine. But I also am a fan of already having it standalone, because that already exists, as opposed to somebody's died, which means it's an event, a big deal for the person with a disability if they've lost a parent. Also, that person with the disability has needs, and it takes time. I'm not saying it takes months and months and months, but it's not like the person dies and the special needs trust is, you know, initiated tomorrow. So I would like to say that, you know, having consideration of how the expenses are going to flow, or how the person's needs are going to be met in the between time of the death and the setting up of the special needs trust, is why, as a parent of special needs, I'm a fan of a standalone. It doesn't mean that the other's wrong, but you should consider and understand what the differences are, so you know, you can make an informed decision on that.
Yeah, and when you have a beneficiary designation on an account, and that beneficiary designation might say, like, you have 3 kids, 1/3 each of my kids, but the one child that has the supplemental needs trust, it goes to the trustee of their trust. All anybody has to do is present a death certificate, and those distributions can be made. So that can happen very quickly after someone passes away. Versus if we're waiting for something to be funded through the will, then we have to go get the will probated. And that might be a few months process. It just depends on the situation. And if there's a low level of assets, it could be that the will just says everything goes to an ABLE account. Now there's $100,000 limit on the ABLE account before it would affect benefits. But if you've got a low level of assets that you don't even need a special needs trust, you could just direct it to the ABLE account, or you could direct it to an ARC special needs trust. So there are some other ways to do it if there's not going to be significant. And I mean, significant meaning over $100,000 in assets going to a trust. So there's some other ways to handle that. Okay, so then supplemental needs trust, ABLE accounts. We could talk for a while on ABLE accounts, and I think we'll just kind of leave this information here. You'll get this. I really suggest looking at, and on the next couple of slides, it'll come up, but it's a website that I think has really great information. That one, the ABLE NRC, ABLE National Resource Center, ablenrc.org right there. You can, it's not advocating for any particular account. ABLE accounts are like 529 accounts, the college savings account, in that they grow without any tax on the income, so income tax free. And it is an amendment to 529A of the Internal Revenue Code.
We
And
do
so-
entire presentations on ABLE and not any ABLE specific, about how it works, how you put money in, how you get money out. You know, what is a qualified distribution from an ABLE account, and all of our past webinars live on that Consolidated Planning Group YouTube channel, so you can check that out. And I agree that the ABLE Resource Center is a good place to check things out. And also, I don't think they take phone calls, but I have emailed them in the past, and they have been relatively responsive on you know, any questions that you have that way as well.
And then just go back one slide before that ABLE account last slide, and then one more back. So this just gives the basic limitation. So the disability has to have started before age 26. There is some proposed legislation to extend that to a higher age. The annual limit is whatever the annual exclusion amount is, which is 19,000 now in 2025. And then you've got to keep it under $100,000. It'll have a SSI eligibility issue. It's cash only, and there's a Medicaid payback of the beneficiary's death. Supplemental needs trusts do not have that Medicaid payback, so that's one of the benefits of doing the planning ahead of time, is to not have that Medicaid payback, which means whatever benefits are distributed for that individual during their lifetime will be paid back at their death. So,
And we should say Texas has a Medicaid payback. Not all states have a Medicaid payback on the ABLE account, so I get the question all the time, Heidi, of well, can I just go get that state's ABLE account? Well, if you live in Texas and you're getting Texas Medicaid, there would still be a Medicaid payback. So it's a clever idea, but it doesn't work. And I just want to add to those limits that if the individual with the disability is working, there is an additional amount of money that they can put in up to their full earnings amount of $15,560 for 2025. So $19,000 for 2025, whether or not they're working or not. If they are working, they can put an additional $15,560 up to that earnings amount. So in that example, when I'm saying up to that earnings amount, if the person's working and they only earned an additional $5,000, then the max additional money that they could put in is $5,000. So
that is really important. And I misunderstood that when it first came out, and Allison corrected me. In that I thought that income could be like exempt from SSI. I thought that it could go straight to the ABLE account and not be an issue with SSI, but it is absolutely considered income for SSI purposes, as Social Security Administration purposes. And then the amount can be added to the ABLE account.
yeah, I mean, I think the amount can be like, it's going to be counted as income. Income is income is income. There's no hiding of income.
Yeah.
But like once that money, that $5,000 moves to that ABLE account, it would not be counted as an asset. So anyway, sometimes there's confusion with all of that and how it works. So I just wanted to communicate that. I know not everybody's loved one works or will ever work, but some of them do. And because some of them do, then they have a greater need of putting more money into the ABLE account to maintain that Medicaid eligibility. So we can help with all of that. So a couple of questions I just wanted to hit on. You know, well, and Heidi and I were talking about this in the beginning, was about childhood disability benefits, because one question that we got today was a write-in. It says, what trust distributions are allowed for residential personal care needs that will not change the SSI payments? That's a great question. And what this person is referring to is that there is a 1/3 reduction when we pay for housing, rent, mortgage payments, things like that out of a special needs trust. There is a 1/3 reduction to SSI. But one of the things that I want to be clear, so basically the ABLE account can pay for housing, without a 1/3 reduction, because sometimes people ask, why should I have an ABLE account and a special needs trust? Don't they do the same things? Well, ABLE account grows tax-free, so that's a benefit. And an ABLE account can pay for some things that a special needs trust can't pay for without a 1/3 reduction to SSI. An ABLE account has a limited amount of money that you can put in, whereas a special needs trust has an unlimited amount of money that could go in. But the main thing that I wanted to be clear on is that when our kids are getting SSI, if their disability started prior to age 22 and they haven't earned more than the substantial gainful amount over a period of time, then they'll be eligible for childhood disability benefits under a parent's record. So when that parent turns on Social Security or Social Security disability, then we need to apply for childhood disability benefits under the parent's record. And that child essentially switches from SSI to SSDI, also known as DAC, also known as CDB. We like all these acronyms, but CDB, DAC, SSDI, Social Security, kind of all one and the same under a parent's record. When they're under SSDI, it's different, and there's not a reduction to SSDI or DAC benefits when we pay for housing out of the special needs trust. And then furthermore, it also depends on where these people live. Every place, these residential places, how they bill for a bed, whether it's for a bed reservation, or it's housing or rent, it just depends on how they bill on whether or not there would be a 1/3 reduction. So that may be a conversation with each of those facilities, because they're all different. We have no way of knowing that.
Let me really quickly respond to a couple of questions. I know we're hitting one, so I'll do real quickly. So Denam Mani said, can a special needs individual revoke a third-party special needs trust? And the answer is no. The trustee or the grantor is the only person that could potentially revoke a trust. These are typically irrevocable. The trustee would have to make a decision about whether this individual was maintaining eligibility for benefits. If they didn't need disability benefits anymore, they could distribute the assets out, and that would be fine. If they were receiving benefits, and they might need to work on a spend down program where they were spending to an ABLE account, paying for needs, that kind of thing. And then Laura Meadows asked about surviving spouse not creating a special needs trust. If you have, I think this raises the question, if you have other family members, either an ex-spouse or parents, grandparents, who might be making gifts in their estate planning to your disabled child, they could be harming your plan too, and you would need to talk to them about, please create a special needs trust in your plan. You can have more than one special needs trust, or please reference the one we've created in our plan. So that would be a good conversation to have with family members.
It's really, really important, because your parents and grandparents and people that might leave your child money, their advisor is not likely nuanced and special needs, and it happens very accidentally, where a person gets named as, your loved one gets named as a beneficiary. And a lot of our family members keep their cards close to their chest, and they want to do something great and they want to do it right. But you have to have those intentional conversations with them, because when they do leave money directly to your child as opposed to a trust, the only fix to a third party special needs, the fix to it is either lose your benefits or go get a first party special needs trust that now has a Medicaid payback. Third party special needs trust does not. So we are out of time today. It's been a great discussion, Heidi, and so thank you for that. Thank you for your questions that you guys wrote in and put in the chat box. If you have additional questions, everybody's going to get a copy of today's slides, a link to the recording. It has Heidi's contact information, our contact information. We always offer free personalized consultations, kind of talk to you a little bit more about the planning that you've done so far, kind of, where you are and what help you might need. So we can definitely help you. We're here to help. We're glad you attended. And this is I always just want to encourage people, don't feel overwhelmed. It is a lot, but there are a lot of people to have at the table and to kind of talk through these things to help you. You do not have to know everything about this. Just know who to call and to get the help that you need to get it done right. So thank you, Cheryl and Elijah's Retreat, for sponsoring us today. It's certainly been our pleasure, and I hope that you guys will check out their website, and we'll look forward to connecting with everybody again soon. Reach out to Heidi for a consultation and kind of talk a little bit more about her services. what legal documents, maybe you have legal documents that have been on the shelf for 15 years, you need to dust them off. We recommend families have those looked at every 3 to 5 years. So maybe you need a second opinion, look under the hood. Maybe you don't have any at all. It's okay. Just reach out and start those conversations. So thanks so much, everyone. And I hope everybody has a great afternoon.
Thanks, Allison. Thanks, Cheryl. Bye, everybody.
Bye now.